Hello, everyone, and welcome to this Federalist Society virtual event. My name is Sarah Clark, and I'm Assistant Director of Practice Groups with the Federalist Society. Today, we're excited to host this FedSoc webinar called Nondelegation and the Limits of Agency Authority after Consumers Research and Loper. We're very pleased to welcome a terrific panel of legal experts today. Our moderator, Adam White, is the Lawrence H. Silberman Chair in Constitutional Governance and a Senior Fellow at the American Enterprise Institute. He is also a co-director of Antonin Scalia Law School's C. Boyd and Gray Center for the Study of the Administrative State. If you'd like to learn more about today's moderator or speakers, their full bios can be viewed on our website, fedsoc.org. Throughout the program, we'll turn to the audience for questions. If you have a question, please enter into the Q&A function at the bottom of your Zoom window, and we'll do our best to answer as many as we can. Finally, I would note that, as always, all expressions of opinion today are those of our guest speakers, not the Federalist Society. With that, Mr. White, thank you so much for joining us today, and I'll hand things over to you.
Well, thank you, Sarah. Thanks so much for hosting this today. And thanks everybody for joining us, especially our two guest speakers who I'll introduce in a moment. But maybe just to set the table to start, Sarah kindly mentioned that I direct a program called the Center for the Study of the Administrative State. And needless to say, there is a lot to study in recent years, recent months, and even recent weeks. It seems like more and more of the Supreme Court's docket or its interim docket is taken up with collisions between administrative agencies and the courts with real questions about how we interpret the laws and how much power those laws can constitutionally delegate to the agencies. Now, this, of course, is a timeless debate and certainly a vigorous one for the last 40 or 50 years. Decades ago, there were debates around delegation and deference. And it was seen, especially through the eyes of Justice Scalia, that the court's work on the non-delegation doctrine and the court's work on Chevron deference really dovetailed together and one followed from the other. And we're now in the middle of a great era of reconsideration and debate, with the justices looking very differently at the relationship between how much power the Congress can delegate to agencies, how much skepticism the courts should direct at those delegations of power, and how much deference, if any, the courts should give to the agencies when in interpreting those broad delegations of power. In recent years, we've seen any number of important cases, some of which under the flag of the major questions doctrine when it comes to deference. But most significantly in recent years, Loper Enterprises versus Raimondo, or as my friends at NCLA like to point out, the relentless case as well, about deference the court should or shouldn't give to agencies. We've also had a major non-delegation case in recent months, FCC versus Consumers Research, which raises, once again, some very interesting questions about how much power can be given to an agency, and for that matter, what kind of agency might be given significant powers. There remains great interaction between these doctrines, and so our purpose today is to talk through how we see these playing out, these themes in the aftermath of Loper Bright and Consumers Research, and especially how the non-delegation doctrine might or might not continue to play a role as a major background principle in the interpretation of the laws that empower agencies. For this conversation, we're really blessed to have two great speakers. It's hard to imagine two better speakers and thinkers on this subject. Let me just introduce them very briefly and alphabetically. Jonathan Adler is the William & Mary Law School's Cabell Research Professor and Tazewell Taylor Professor of Law. He's one of the nation's leading scholars on administrative law generally and environmental law specifically. His most recent book, I believe, is Climate Liberalism, Perspectives on Liberty, Property, and Pollution. And among his many other books, you'll also find 2019's Business and the Roberts Court. And our next speaker is Elon Werman. Elon is the University of Minnesota's Julius E. Davis Professor of Law, where his widely read scholarship focuses on the 14th Amendment, administrative law, separation of powers, and constitutionalism more broadly. His latest book is The Constitution of 1789, An Introduction. Elon, I can't tell if you're on mute right now, but I'm curious, is that book out already or is that forthcoming? I know I'm seeing it around.
It's supposed to be coming out on July 4,
Ah,
2026, the quarter millennial or the semi-quincentennial, if you like even more Latin. But my
yeah.
publisher is Cambridge University Press, and so I don't know if the British still hold a grudge about this or not, but
Ah,
we'll find out.
well, that's great. And yes, the word is semi-quincentennial. It just rolls off the tongue. So that'll be his next book. But among his other books, there is the case book, Administrative Law Theory and Fundamentals, An Integrated Approach. So again, many, many thanks to Jonathan and to Elon for joining us today. And I think if it's okay, I'm going to turn first to Jonathan. Just very, very broadly, Jonathan, you've of course been following and writing on these issues of deference and delegation for many, many years. Among your more recent articles is the piece you put out just a couple of years ago, not even 2 years ago, in the Harvard Journal of Law and Public Policy's Per Curiam, and it's titled simply The Delegation Doctrine. Could you just maybe give us a brief overview of how you see the current state of delegation and deference, whether they're still rowing in the same direction, and just help us better understand the present moment?
Sure, happy to do that. And first, I should say it's a pleasure to be here for the Federalist Society and to be here with you and Elon to talk about these issues. So, the hypothesis of this article, and this article was originally presented at a symposium shortly before Loper Bright was decided, is that we've spent a lot of time talking about non-delegation. But it seems to me the court is more interested in delegation. And let me explain what that is and perhaps suggest why that is. Um, so what I basically argue is that it is axiomatic that at least when we're talking about domestically, federal agencies only have those powers that Congress has delegated to them. And in so many areas of administrative law, the ultimate issue that legal issue that is presented is what power was delegated to the agency, because that will, of course, affect whether or not the agency action was in fact proper. Did the agency exceed its power? Did it comply with the conditions placed on that power, whether they are substantive or procedural? And throughout administrative law, we're focused on this question. And what I tried to argue there, and I think both Loper Bright and FCC versus Consumers Research are consistent with my hypothesis, is that the court's not entirely sure where the outer boundary of permissible delegation is. It's not clear, to quote Justice Gorsuch, it's not clear how to answer what is the test beyond very broad statements about the need for an intelligible principle or the need to not delegate too much, that the court doesn't know how to operationalize that. But what it does know how to do is to look at statutes, to look at whether or not those statutes delegated power, and to pay particular attention to those instances in which agencies or others are claiming that the power that has been delegated in a meaningful way shifts our constitutional baselines. That is to say, reallocates authority in a way that is particularly meaningful. And then as a consequence of that, you, I think, get not only the major questions doctrine, but you also get the idea that agencies aren't due any deference in when it comes to questions that relate to the scope of their own power or perhaps the scope of their own jurisdiction. This was an issue in a case some time ago called FCC versus City of Arlington. The Chief Justice wrote a dissent in that case. And part of my hypothesis is that while the court in that case rejected the idea that Chevron deference wouldn't apply in the context of questions of the scope of an agency's own jurisdiction, the Chief Justice's dissent in that case has basically been vindicated since. That when you look at the substance of the Loper Bright opinion, you look at the major questions opinions, and I think even when you look at the way the court has been handling non-delegation cases like Gundy and FCC versus Consumers Research, you see the Chief's concern about really making sure that any power exercised has been affirmatively delegated by Congress, that we don't let silences constitute implicit delegations. We don't let agencies tell us what power they have. We, in fact, look to what Congress did to see what power was given. And so I think that that's the way the court has been approaching these issues. And just really quickly about why Loper, Bright, and FCC versus Consumers Research are consistent with that. I think in Loper, Bright, it's very clear that the court is focused on delegation and what power is delegated, that's what we want to know. Did Congress delegate the power to the agency to say, you, a fishing boat owner, you have to have a monitor on your boat and you have to pay for it, right? We don't care about whether that's a good or bad idea when it comes before the courts. We don't care about what the agency thinks about that beyond any particular insight they have or something they can identify that shows evidence of what Congress did. Rather, we want to know what was delegated. But then in FCC versus Consumers Research, I think you see in that case very clear concern, not so much about non-delegation in the sense of Congress may have delegated too much, but real concern about whether or not we construe the statute that Congress enacted to delegate more broadly than perhaps it actually did. And we could argue, and perhaps maybe we'll discuss, there is in that case, like we saw in Gundy, a very big dispute between the majority and the dissent about what the statute means, right? I've just taught both of these cases to my students. And one of the things we talked about is if you just read the way Gorsuch characterizes the statutes, oh gosh, these look like really big, scary delegations. But if you read the way the majority construes those statutes, it actually looks like a relatively small delegation. We're really only giving the agency the power that Congress very clearly delegated. We assume that power has conditions. We assume that power has limits. And in FCC versus Consumers Research, the Chief Justice, Justice Kavanaugh, and Justice Barrett all go along with this opinion that in some respects avoids the non-delegation problem by paying a lot of attention to ensuring the agency only has that power that was affirmatively delegated to it by Congress. And I'll stop there.
Well, Jonathan, that was great. And at risk of putting you on the spot, since you brought up the Consumers Research case, would you mind just saying a few more words about what the case is about so that everybody who might not be as familiar with it knows? I'll tell you, I scanned the participant list, Jonathan, and I know there are a lot of people on this call who know what that means, a number of academics, and I'm glad because it means we'll get great questions.
Sure.
And a number of practitioners too. But just maybe a few more words about what the case is about.
Right. So, and I'll just at a very broad level, Congress, throughout the history of the various Telecommunications Act, has always been concerned about making sure that there is universal provision or universal service for at least some amount of telecommunications services that we all have the ability to connect at one point in time. It was telephone service. Today, obviously, it's things like broadband and the like. And the way that is provided for is that the FCC determines what universal service should cover, what is required to make that happen, and then perhaps most controversially, to assess fees, taxes. There is some discussion about that, but basically to require the providers to fund the provision of universal service. And for those of you that aren't telecom folks, take out your cell phone bill. You will see the line on the bill that is this universal service fee. So the two issues that were really teed up as non-delegation questions, one was this question of whether or not do we treat an agency's authority to impose what might be a tax differently than the delegation of, say, power to regulate commerce. And obviously, this was something that came up in the tariffs case as well, but the idea that should the delegation of this power be viewed differently? And then secondly, because the FCC uses this kind of quasi-private entity to collect the money and to help it determine how much to assess, was there a violation of something called the private non-delegation doctrine? The idea that it's one thing for Congress to delegate power to an executive agency or perhaps even an independent agency, something distinct if power is being delegated to a private entity. And then the U.S. Court of Appeals for the Fifth Circuit had concluded that whether or not either of these features of the statute individually were a problem, that when combined, they created a constitutional problem. So this is kind of the Free Enterprise Fund versus a Public Company Accounting Oversight Board approach to finding separation of powers problems. The idea that things that push constitutional boundaries by themselves may still be okay, but when you layer them on top of another, you may sufficiently subvert the underlying constitutional value to create a problem. The Supreme Court 6-3 rejects all three of these concerns, basically saying we apply the intelligible principle standard for delegations without regard to which of Congress's enumerated powers has been delegated, or if you prefer, subdelegated to the agency. The agency itself retained ultimate control and authority over what was being done, so there was no view or no problem with the private non-delegation problem. And then, since neither of these were a problem, adding them together wasn't a problem. Just note, the majority did say that the intelligible principle test is a requirement, and it did say that that means that Congress must resolve the general policy question, and that there must be some limit, some outer limit to the power that's been delegated, but didn't think that this statute violated that limit. And actually, last little point here, I think very much like in the Gundy case, the framing of Justice Kagan's opinion is not, gosh, this is a delegation of a lot of power, maybe we've reached the limit. It's rather to, at every turn, characterize the statute as delegating less. So when you finish it, you actually think that if there's a statute that pushes the bounds of the non-delegation doctrine, it's not this one. Whether that's a fair reading of the statute or not, we could debate, but I think that's an important aspect of the way the court approached the statute in this case.
Well, thanks, Jonathan. And I definitely want to circle back to that last point in a little bit. I find it very interesting. But before I do, Elon has been very, very patient. Elon, if I could bring you into the conversation now. First, just at a very big picture, same general question I asked Jonathan. After all, you've written a lot on non-delegation and deference over the years. Your own article, Non-Delegation at the Founding, has been sort of widely read and debated. How do you see the current moment in the aftermath of Loper Bright and consumers research and other cases? How do you see the current moment in delegation and deference?
Sure. So Jonathan really set us off very, very well. So I'm going to try not to be too repetitive, but maybe say a similar thing, at least to start, in another way, which is that the Loper Bright case is really about delegation. And so, but let me say it in a bit more of a controversial way, which is I don't understand why that wasn't a 9-0, which is, by the way, my MO. If I could make something more spicy, I will. Why it wasn't a 9-0 decision, it just I really cannot understand. So if you look at Justice Kagan's dissent, she says a couple things. She says, well, at Chevron step 1, which was the interpretive step, right? Is the statute ambiguous or is it clear? That's a rigorous step, and you must deploy all the tools of interpretation, right? But she said it's rigorous. Now, one might question whether that's an accurate assessment of the way the lower courts had actually deployed Chevron step 1, because a lot of them were finding ambiguities pretty regularly. But okay, so let's grant what she says, that step 1 should be rigorous. And then she says, but sometimes the statute's just ambiguous after all the tools have been done. Now, what does she mean by ambiguous? She doesn't say this exactly in the Loper Bright case, but she does say it in the Kaiser case, which is about our deference. So it's very similar, like an interpretation of an agency's own regulations. And she says, sometimes you've deployed all the tools of interpretation and the law just runs out. Excuse me? Well, if the law has just run out, then what are you interpreting? So step 1 is rigorous. You've deployed a bunch of law, and then sometimes the law runs out. So what are you interpreting? There's no more room for interpretation. What you then have is delegated policymaking discretion. Maybe it's gap filling, right? Chevron has always been an example of gap filling in my view, right? We know Congress wants to regulate this thing called stationary sources. There are 4 terms that define stationary sources, but sometimes more than one of the terms applied. And so is a power plant that has multiple smokestacks a facility, an installation, right? A building? Like, do you treat each smokestack or the whole unit? We know Congress wanted to regulate this thing, but it just left this gap. Like, what happens when more than one definition applies? That's interstitial policymaking, delegated necessarily, right, by the gap left by the statute. And some delegations are broader, like, just and reasonable rates or do what's feasible, right? Sometimes it's this grant of lawmaking discretion. Okay, so if that's the kind of the thrust of Justice Kagan's dissent, well, what does the majority say? The majority said the same thing, that sometimes the best reading of the statute, and they cite here the late Professor Henry Monahan, where he wrote this famous article in 1983 about this, where he says sometimes the best reading of the statute is it delegates discretion to the agency. That isn't interpretive discretion. It just delegates policy-making discretion, like make national ambient air quality standard requisite for the public health and with an adequate margin of safety. Okay, some of those terms you have to interpret. Okay, but we know what safety is. We know what margin is. We know adequate. We know what that means. These things just call for policy judgment. So this is about not interpretation. It's about policy making and delegation, and therefore the only back end check on it, other than the best interpretation of the statute, is the non-delegation doctrine. Now that raises this question of, okay, so if this is really policymaking discretion, doesn't that just violate the non-delegation doctrine? And Justice Thomas gets close to saying this in a couple of cases. And it depends on your view of the non-delegation doctrine. So if Justice Thomas's view is correct, which I take to be that the formulation of generally applicable rules of private conduct is legislative, then all legislative rules under the Administrative Procedure Act, I mean, that's like kind of literally the definition of a legislative rule, all of them would be unconstitutional delegations of legislative power. That's one view. I don't know if that view is right. I mean, it's certainly the case that a lot of things, this is an important concept, that a lot of things that Congress can do doesn't mean it has to do, right? The executive could also do a lot of the things that Congress can do. So one of my favorite examples is one of the perhaps first regulation ever promulgated was the invalid veterans regulation, where Congress said we're going to pay the invalid veterans of the Revolutionary War, as we did before in the Confederation Congress, under such regulations as the President of the United States may direct. And he said, okay, show up on these 2 days, we'll pay 2 equal installments, here are the vouchers and proofs that you need. Could Congress have done that? Of course, Congress could have done it. It doesn't mean it isn't an exercise of executive power when the president does it through an instruction from Congress. So the question becomes, right, what is this, recognizing that there's overlap in the reach of legislative power and executive power? What is the scope of the things that only Congress can do? Maybe it's the establishment of intelligible principles. Maybe it's the regulation of private rights. And so that will depend on your theory of the non-delegation doctrine. The only other thing I'll say about that, and then I'll stop, is I think for a long time, people have been saying quite persuasively that the nature of the right surely matters. Okay, I don't know that Justice Thomas is right. Every regulation affecting private conduct, I just don't know if that's right. But surely, a law that imposes criminal penalties or that affects life, liberty, and property is more important, is the kind of thing that we would expect the legislature to decide than, say, matters of official conduct, organization of the government departments, or even the creation of a social security program, like a public rights scheme. It doesn't mean Congress can freely delegate in the public rights scheme, right? Congress couldn't just say, President Washington, you figure out if we should pay invalid veterans. Okay, and who appropriates for that, right? So legislative power reaches all of these things, but our intuition tells us that the nature of the right matters. And here's where consumer research really kind of flubs it, as Jonathan suggested, or actually both of you, I think, Adam, you set this up. This kind of looks like a tax, right? Has Congress ever delegated this kind of discretion to impose exactions? I really don't know what you want to call it without making the question on the people. This would have been an opportunity to tell us whether the nature of the thing delegated or the specificity of the principles required may vary with the nature of the power that is delegated. And since we talked about the anniversary of the American Revolution, let me just say that this was a grievance. And the briefing and the case really doesn't get it. When we say taxation without representation, this included determining the quantum of the amount raised. So one of the solutions to resolving the American Revolution grievance, which wasn't actually going to resolve it, was requisitions. So Parliament would decide we want X amount of taxes, and the colonial assemblies would then raise the taxes. And they said, okay, no, that solves one of the problems. We decide the mode of taxation, but it doesn't solve all of the problems, where we also get to decide on what we spend it and the quantum of the amount. And because I thought I might talk about this, I pulled this up, and I'll stop after this passage from Edmund Burke. It has never been the complaint of the Americans that the mode of taxation was not left to themselves, but that neither the amount and quantum of the grant nor the application was in their free choice. So this was literally one of the grievances of the American Revolution, and it just would have been nice to see a bit more analysis from the majority about why that quantum can just be freely delegated to somebody else.
Well, Elon, as you're sketching that out, and I really hadn't thought about the connection to taxation at the founding. You know, back in 250 something years ago, that kind of thing led us to throw our tea in Boston Harbor. Maybe what you're saying is, after consumers research, we should all go to Boston Harbor and throw our cell phones into Boston Harbor. But in more seriousness, what you just sketched out, and your reading of Loper Bright, especially as raising the delegation issue, I'm not sure which way that cuts, and I'm curious to hear your reaction. I mean, on the one hand, we live in a time where a lot of folks think that the court, more justices on the court, are as inclined than ever to resuscitate a stronger non-delegation doctrine. But what I thought I just heard you say is that Supreme Court majorities, in a majority at least in Loper Bright, is seeing the delegation with clear eyes, and maybe other than Thomas saying that this is fine, this is just how government works. What's the upshot of Loper Bright as you see it for a new non-delegation doctrine? Are you saying actually it's less likely than before, or it's more likely than before?
So in one respect, on the merits of the decision, we actually don't know. All they've said is, in Loper Bright, to the extent this is an interpretive question, we will decide the interpretive question.
Mm-hmm.
They didn't say anything else about to what degree discretion can be left to the agency, the scope, or degree. In that sense, it wasn't a non-delegation case. Having said that, there's no question that this will have a ripple effect in the sense that non-delegation challenges are just going to be rarer now, because Chevron deference encouraged non-delegation challenges, because not only, as we all recognize, Congress delegates in extraordinarily broad power, we all know this, but then to say, well, and the agencies can take that already extraordinarily broad delegation and make very adventurous interpretations, and we're just going to defer to that, well, then it's the broad delegations even broader than we had anticipated, inviting these non-delegation challenges. But now we're saying we're not doing any of that. So we're going to interpret it strictly. So maybe there are these broad delegations, but we're not going to give deference to even more adventurous interpretations of those delegation. And then you combine that to major questions, which can't remember if we want to talk about that at some point. But so not only are we going to demand the best reading of the statute, but in certain cases, we're going to demand more than the best reading, a clear statement. Then when are you going to see a delegation challenge arise? Only where Congress clearly and unequivocally delegates broad and open-ended power to the president. Is that the tariff case? Yeah. I actually don't know. It doesn't. It's not clear, and you kind of have to read. Well, what's clear, right? I mean, that's a separate question. So a lot to talk about.
There are great questions, by the way, coming in from the audience. I already see some here from Greg Troutman, John Scheller, and anonymous attendee, if that is their real name. And we're going to get to as many audience questions as possible, so folks, please keep submitting them. But Jonathan, to turn back to you, before I just get right to the tariffs case, because I do want to ask you too how you see at least the themes we're discussing today, how they relate to the tariff case. Elon just ended with a reference to the major questions doctrine and the notion that some of the canons of construction the court is using these days, they seem less like what's the best way to read the statute, and more substantive. And so, do you have anything to add on this in terms of the court's embrace or skepticism of substantive canons in these deference and interpretive debates? I know Justice Barrett might see things a little bit different than others. How do you see right now the role of substantive canons in the court, and whether that might change?
Well, two things. First, I wanted to really highlight something that Elon said, which is also a point that I made in my delegation doctrine piece about how some of these pieces fit together, especially when major questions is on the table. There's a kind of a conventional narrative. I know Cass Sunstein has made this argument, others have, that as the major questions doctrine developed, there was like the small ball version of it, which was you don't give Chevron deference when there's a major question. And then when we got to West Virginia versus EPA and the student loan case, then we got the big version or the aggressive version of major questions doctrine, because that was about whether the power exists. And I think what Elon suggested, and he'll correct me if I'm mischaracterizing him, that's actually backwards. That to say that Congress delegated big power X is less of a delegation than to say Congress delegated to the agency the power to decide whether to exercise big power X, right? That is to say, think about King versus Burwell. The question of whether Congress had authorized the tax credits was a lesser deal than did Congress give to the IRS the authority to decide whether and to what extent to authorize tax credits, right? And so, because that latter, what we were saying, oh, it's just minor because it's just about Chevron deference. No, it's much more significant because that's much closer to the real legislative choice that the non-delegation doctrine is supposed to guard against. So the kind of conventional framing of the way major questions relate to these questions has it entirely backwards. Granting Chevron deference to these sorts of matters was a much larger delegation of power. And I think Elon's also absolutely correct that a consequence of Loper Bright is to close that door. And so it's to take off the table a lot of contexts in which we might have made non-delegation arguments. And Justice Kavanaugh, in his concurrence in FCC versus Consumers Research, kind of makes this point. The first part of his concurrence is, as he walks through the intelligible principle, kind of the history of it, he makes the point, which he had hinted at before, which is that the major questions doctrine and some other doctrinal developments of the court are really removing non-delegation concerns or adequately addressing non-delegation concerns in a lot of contexts. Well, in the court's view, adequately addressing non-delegation concerns. I'm sure, whether or not that should satisfy folks that want a more aggressive non-delegation doctrine or not, separate question. In terms of how this relates to canons, I think that's a fascinating question. I mean, I think for the court, I think the view is, and certainly, this may be projection on my part because, I've articulated it this way. But if you recognize that our starting point is that all legislative power is vested in Congress, agencies neither exist nor have power to exercise unless and until Congress has delegated power, then we are looking for affirmative grants. We are looking for things that actually transfer and shift power. That's not something that happens with a shrug. That's not something that happens just by implication. And so I do think it is fair to say that when we're thinking about documents that delegate authority from a principal to an agent, we look for actual delegations, right? Silences aren't ambiguities. Silences aren't possible delegations of power. Silences are a failure to delegate. They are a lack of delegating that power. Now, I do think some people hear that and they think that's a substantive canon as opposed to a common sense way of understanding the nature of an instrument that transfers or shifts or delegates power. And at some level, I think that may be something of a semantic debate. I think Justice Barrett in particular has explained why we normally understand delegations of power, and Elon's written about this as well, right? We understand them in their context, and we're not interested in just, semantically, can we squeeze something into the particular text? We actually understand that the language in the document or the language in the instruction is doing something, and the context helps us understand what it is doing. And it is actually aiding our understanding to keep in mind the idea that more language is required to do more, to put it in very simplistic terms. So I think in some sense, the court doesn't really think this fits into is this a linguistic canon or is this a substantive canon kind of dichotomy? It's rather just the way we understand instructions or delegations of power requires us in context to recognize that the more that is accomplished or that language has to be more explicit or more complete in order to accomplish a greater delegation.
Elon, I'm sure you want to jump in on that, but I'm tempted to just make the subtext text with you and just ask, how do you think the things that we're discussing right now relate to the tariffs case? I'm not saying could you guess how the tariffs case will be decided, but could you maybe just apply some of these themes with reference to the tariffs case, right? The interpretation of what the word regulate means in the 1977 International Emergency Economic Powers Act. Can the word regulate be, reasonably interpreted or construed as including a power to impose tariffs? I mean, so much of what we've discussed surely touches on the question at hand before the court.
Yeah, so does the American Revolution, by the way. So
Okay.
I will come back uh, to that point. By the way, the tariff case was my exam for administrative law last year, and I chose it because I don't know. You tell me what to think. It could go kind of either way, and you could deploy a lot of these canons and arguments that we're talking about, which is why it was a lovely exam question. Let me say quickly something about, though, if I may, the substantive canon thing, and then I'll jump into this. I promise, Adam. So I do think it's weird to use the ordinary clear statement rule as a justification for major questions, because ordinarily the way clear statement rule works is Congress can do the thing in question as long as Congress is clear about it. But can it? I mean, that begs the non-delegation question here, right? So maybe it's an avoidance canon, but then if it's an avoidance canon, you have to tell us, okay, but why might it violate the Constitution if, Congress? So it doesn't really fit. So I'm of the Barrett camp here. I'm going to say Barrett-Werman because I have a paper that came out about the time that Biden v. Nebraska came out, called Importance and Interpretive Questions in the Virginia Law Review, where I basically say that the major questions doctrine is actually supported by a linguistic intuition. And what I mean is, ordinarily, people expect important things to be conveyed or delegated with more clarity, like the more important it is. The only reasonable empirical study we have, the way Congress drafts this Lisa Abby Gluck, Lisa Bressman study, says that, yeah, we don't, of course, Congress, to be clear, Congress likes to delegate big policy questions. It likes to pass the buck on big policy questions. And it often uses strategic ambiguity, right? But the question is, does it delegate big questions through ambiguity? And the answer is no, we usually don't do that. And so an empirical study shows that linguistically, our intuition tells us that before something is done fraught with tremendous consequence, we expect more clarity. It's in the restatement of agency law about how agents are supposed to interpret the principles. Now, how does this relate to all the substantive canons? And that's the rub, and this is where I get into some trouble. Maybe all the substantive canons are actually ultimately justified by this linguistic intuition about the more important something is, the more clarity we demand. And whether something is important or not will depend on things we think about our legal system. Whether the presumption against preemption, is that an important thing? The Charming Betsy canon is based on our background presumption that actually it's kind of a big deal if we violate international law. So is that a substantive canon or just linguistic? Because we expect more clarity before we do big and important things. Okay, having said all that, how does this all go into the tariff case? Well, it depends on what the meaning of clear is, right? So here it says regulate transactions in foreign commerce. Can the imposition of a tariff be a regulation? Well, 250 years ago, on the eve of the American Revolution, everybody thought yes. This is why the Stamp Act was unconstitutional as an internal tax, because as an internal tax, it could not possibly be justified as a regulation of commerce. External taxes could be for the purpose of raising revenue and also would be invalid. Okay, but why were the navigation acts of I think it was James II, or no, Charles II. Why were those okay? Why was the Sugar Act of 1733 okay, but not the Sugar Act of 1764? Well, because there's a little argumentation going on and maybe a little sleight of hand, but the colonists said, well, one was to protect British manufacturers and the other was to raise revenue. And so they understood that tariffs could have a regulatory purpose. And I think the Solicitor General tried to get at this argument in the tariff case, and he was laughed at least online, at least on Blue Sky, I don't know, maybe less on X. But this is exactly the argument the American revolutionaries made and the colonists made. And so it really depends on whether we still have that intuition that tariffs can be imposed for the purpose of regulation rather than raising a revenue. Now, it doesn't help that the president has said things like, look at all this money we've gotten, right? But still, that if it's merely incidental to the regulatory purpose, you could raise a lot of money, right? It just... So anyway, let me stop there. I've gone on long enough, but I'd love to hear what Jonathan thinks without prognosticating about how he would approach the tariff case.
I mean, Jonathan, feel free to prognosticate if you want, but all I really am asking is, if you could apply them a little bit more generally. And by the way, after you answer this, folks, we're going to roll through some of these great audience questions.
Yeah, also let me say a tiny bit about the tariff case. For those folks that really want to hear me in adamant length on the tariff case, I think there's a FedSoc teleform of where we did that. I think the way I view these applying to the tariff case, and it's not quite the way Elon was characterizing it. I think a lot of weight ends up being put on how we conceive of the tariff power as whether it's domestic or foreign affairs, and that's somewhat similar in terms of internal versus external tax and the like. And my own priors are that tariffs, because they are paid by the importer, the way we currently administer them, shouldn't be viewed as inherently an exercise of foreign affairs or national security, in that the IEPA leaves on the table all of the truly regulatory measures that can be adopted, and that certainly can be adopted today, right? Because there's a second order issue of, and during the founding period, the tools that really could be deployed was a much narrower set, right? Why do less developed countries do tariffs as opposed to other forms of taxation? It's because it's so much easier without an administrative state and whatever else to do tariffs. But all that means, I think that in thinking about both the delegation and the interpretive question, if we think that these tariffs or the delegation of tariff authority is an exercise of foreign affairs or national security authority, then we have doctrine that says we're less worried about the scope of the delegation to the president. We have a lot of the same intuitions that Elon was just talking about, that we're just less concerned about the scope of the delegation, both because we understand that Congress may give the president a longer leash when it comes to foreign affairs and national security, because of the executive's comparative advantage in dealing with those sorts of questions as compared to domestic questions, and we're less concerned about the effect on domestic liberty. So, it's worth noting, Justice Kavanaugh, in his concurrence in FCC versus Consumers Research, Justice Gorsuch in his dissent, even as well. If you go back to his dissent in Gundy, there's a line on this as well, and you go back to Rehnquist's opinion in the benzene case. All make this observation that the sorts of things that drive the concerns about non-delegation, as well as those concerns that drive the court to adopting narrowing constructions or narrower interpretations of what has been delegated, are just less present in the foreign affairs context. So I think in the tariffs case, a lot matters, or a lot turns on whether or not the justices view this as taxation, imposing burdens on the American people, or the president exercising national security power. And because if it's the former, then I think it's really hard to distinguish the tariff case from some of the cases we've seen involving major questions and the like. But if it's about foreign affairs and national security, well, then we're in a different environment, and it's much harder to write the opinion that curtails them or strikes them down.
Great. Well, let's stick with the tariffs case for just another moment, because we just got a question from somebody who knows a lot about litigation around tariffs, Alan Morrison. Here's this question, guys. Even if IEPA, the statute from 1977, can be read to allow Trump to impose tariffs, how does it satisfy the requirements in Consumers Research that there must be some limits on the amount and duration of tariffs, let alone judicial review, when there are no conditions in IEPA that relate in any way to tariffs? Who wants to tackle that one first? Jonathan or Elon? I'll let you just jump in.
I'll just say, I think that follows from my last point, right? If we view this if this case is occurring in the same box that West Virginia and the student loan case and FCC versus Consumers Research were in, then I think Alan's question is a pretty lethal question, right? Is it because Justice Kagan says you may not need a numerical limit on the delegation of power, but you do need a limit. It needs to, if it's not quantitative, it must at least be qualitative. And she makes an argument why the Communications Act does in fact impose a qualitative limit, does give courts the ability to identify. Sorry, that's my vicious guard dog. It does give courts the ability to identify an agency having exceeded the scope of its delegation. But if this is about foreign affairs and national security, it's not entirely clear to me, at least, that those same limitations would apply. I think that's part of the implication of Kavanaugh's separate concurrence. But if we view this the way we view domestic delegations, it's an incredibly important point.
Interesting. Elon, anything you'd like to add to that one?
Yeah, just Alan, I agree. So I agree both with what Jonathan just said, right? In the consumer research context, I actually think the court was wrong to not go further and say a quantum was important because I understand it to be a tax. And I quite frankly don't understand how you can't. Some people don't see it as a tax. But if a tariff is for a regulatory purpose and not for the purpose of raising a revenue, then it is not a tax. And so the standard, you wouldn't need necessarily a quantum. Having said that, what is it, Holmes, who said a page of history is worth a volume of logic? Well, here we have a couple volumes of history where all this tariff legislation and tariff delegations always said upon the occurrence of X, Y, or Z condition, as declared by the president, the following tariff schedule springs into action into place. Now, J.W. Hampton was a bit broader because the president had the power, as you know, Alan Morrison, to actually equalize the tariffs. But even then, equalizing tariffs for the cost of production, yes, a lot of discretion, but not infinite discretion. So yes, I think if you just look at the historical record, if it's interpreted to allow anything from a 100% tariff to a 0% tariff, if Mark Carney upsets the president, is a possibility that requires a tariff or allows a tariff versus some actual other threat, or then I don't know what the limits are, and that probably is problematic. And so, I mean, I would be surprised. I didn't want to prognosticate, but here I am. I would be surprised if the court didn't limit it in some way. And they might say you can do tariffs, but actually, here are the intelligible principles, which wasn't really litigated very much in the case. Here are the intelligible principles, such that 90% of these tariffs might actually be okay. But just because Mark Carney insults you doesn't mean you can impose some tariff that is beyond the intelligible principle. So it exceeds the statute. Not that the statute violates the non-delegation doctrine, but the court rarely does what I think it's going to do or what I think it should do. Maybe is the way to put it.
Well, Elon, I really want to move on to John DiLorenzo's great question about what's happening in the States, but I just have to ask, a few times you said that, in context of the tariff case, the court's interpretation might vary depending on whether the purpose of the president's action here is, or not that its interpretation would vary, but that the outcome of the case would hinge on whether the purpose of the tariff is to raise revenues or to regulate trade. And I don't actually understand how that would work. Are you saying the courts, or starting with the trial court, would need to kind of hold a hearing on what a president's purpose is and decide whether the president's being truthful or not about that? I mean, that's the kind of pretext analysis that the courts normally avoid, although we saw some of that in the recent census case. Just a quick word on that.
Yeah, I think you would do it the way the American colonists. Sorry, I've just been reading a lot about the American Revolution because I'm excited about the 250th anniversary. They did it from, you look at the text of the Sugar Act of 1764, and how is it different than the Sugar Act of 1733? Well, the preamble said is for purpose of raising a revenue, right? Which it wasn't before. When you look at the effect, that basically it wasn't actually going to help manufacturers, and that the tax was actually so low that it was, and that's also why the tea tax was made so low that the colonists would have to pay it, which is why they dumped it overboard, because they didn't want it unloaded and to set a precedent, right? So you don't have to depose the president. You can look at the face of the executive order. You could look at the face of any instruction given by the Secretary of Treasury. And just like a statute, you would ask, what is the natural and reasonable relation of this tariff to a regulatory purpose, or is it for a purpose of raising revenue? And you can rely on things in the public record, I think, without having to depose. So it's like it's a law question.
Yeah.
I think. Maybe a mixed question of law and fact. I mean, that's the best I could put it.
Now, on the tariffs case, we're going to give Alan Morrison the last word. He posted sort of a follow-up question in the form of a rejoinder, just saying, even if it's not the same limitations, there must be some limitations in the statute, and here there are none. But I do want to move on to the state question that John DiLorenzo raises. He points out that in Oregon, the state has walked away from Chevron deference, but hasn't necessarily resuscitated a stronger non-delegation doctrine. And just to summarize this question, I'm curious, do we think that the Supreme Court, will sort of draw from the examples of states as they continue to grapple with the future of deference questions and delegation questions. There has been a lot of great scholarship on this over the years, surveying what's happening in the states. The Harvard Journal of Law and Public Policy published a symposium a few years ago where state Supreme Court justices were writing on the trends in their states. How do we think about this connection between the states and federal doctrine? Are the state Supreme Courts laboratories for new delegation and deference doctrines, or is the context of federal law and the federal Constitution in the Supreme Court just too different? I'll turn to Jonathan first.
I think we see this going both ways. I mean, prior to the Loper-Bright decision, it was pointed out that there were states that had never had Chevron deference. And I think that certainly informed the way the court thought about this question. I suspect it made it for a couple of the justices that recognition might have made it easier to take the step of overturning Chevron. And I think since then there are state courts that had adopted Chevron-like approaches that have backed away from that, following the cue of the federal government. And I think that's something that we see more broadly, that we see in state Supreme Courts. We sometimes see kind of reflexively, these courts reflexively following the cues set by the Supreme Court, unless there's something distinct in their particular constitutional tradition that gets in the way of that. But I think we're starting to see more attention to the details of state constitutional law, and so we're starting to see more of a dialogue. And in these areas, it's certainly important to remember that state constitutions on separation of powers questions are often quite different than the federal constitution. Among other things, a lot of states don't have unitary executives, for example. You also sometimes see agencies provided for in state constitutions and given power by the Constitution, and therefore not solely dependent upon legislation. So those differences, I think, mean that while what's occurring at the federal and state level, why they inform each other, there's often this translation that has to occur because the state context can be different from the federal one.
Elon, in addition to asking what might the federal courts learn from state courts in terms of federal doctrine, John Scheller asks the question, sort of looking through the other end of the telescope. He says how we might think about these federal principles, these federal jurisprudential principles, applying to state or local government, given the differences between federal agencies and their parallel state and local agencies. So feel free to answer either what the federal doctrines might learn from state developments and what the state doctrines might learn from federal developments.
So I'm sort of a believer, but not really, but sort of a believer in this thing called general law, maybe not general law, and it wouldn't apply in this context, but the common law process, which includes some general law, includes some state-specific law, where a lot of jurisdictions arrive at similar rules because of the artificial reason of the common law as elucidated over time by various problems and various jurisdictional actors. And so it wouldn't surprise me if there were lessons to be learned across the board, and that the states and the federal government, although at some point are out of equilibrium, eventually do very similar things, subject, of course, to the differences in their text. So one example here, which I think might end up being in equilibrium. I have some experience with Arizona where I taught for 6 years, and a few years ago it purported to abolish Chevron deference. And the funny thing is, I'm not actually sure that Arizona ever had Chevron deference, because when you look at what the courts did in Arizona, it was long-standing interpretations of the executive department are entitled to great weight. That's not the same thing as deference. And in the federal level, and Aditya Banzai has a great article about this, that's also a doctrine. Long-standing interpretations by the executive department, particularly those contemporaneous with the enactment of the law, are good evidence of what the law probably means, especially if you're a court sitting decades later, decades removed from the question. And so they're entitled to great weight. It wouldn't surprise me if the federal, now that Chevron deference is gone at the federal level, that federal courts will start deploying the long-standing and contemporaneous exposition canon more, like it used to prior to 1984, and that the states will also then realize, hey, actually, this is what we've been doing for much of the time rather than deference, and that there will be this sort of uniform reemergence, reinvigoration, resurrection of these two venerable canons of interpretation that I love putting on my exam for any students listening.
Now, a lot of the court's decisions around deference and the major questions doctrine speak not only of the courts and the agencies, but also Congress. both in terms of how we think about what Congress is doing and how we think about what Congress should be doing. And we have a couple of questions about that. Michael Weiser asks whether Loper Bright has actually done anything to actually place more responsibility on Congress to write more detail into the statute. And so the question would be, how, if at all, is Congress actually reacting to Loper Bright? But then Greg Troutman asks a great question. He says, say there's a case where the Supreme Court strikes down a regulatory program under the major questions doctrine. Say Congress goes back and writes new legislation in the aftermath of that. How differently, if at all, should the courts go about interpreting these new statutes? I mean, maybe one version of the question would be, say say an agency's program is struck down under the major questions doctrine. The court says, we presume Congress will speak in greater detail if it wants to authorize this. What if Congress goes back and re-legislates the exact same thing in the exact same terms without any greater detail? How might the courts think of that iterative legislative process? So Elon, feel free to take either or both. Is Congress doing more in the aftermath of Loper Bright? And if Congress were to do more, would that affect the court's approach in sort of an iterative way?
So I don't know on the first question. My guess is it's too soon to tell, but Professor Adler may know more. On the second question, of course, the Clean Power Plan, Congress could always have enacted it directly. Then there's no problem. But if Congress had come back and said, no, actually, we think a system, the best system of emissions reduction can mean the national energy system. And therefore, we give the agency discretion to decide whether to do outside the fence line distribution regulation of the mix of energy production in the country or something like that.
Mm-hmm.
Then that would be the non-delegation question. And which goes back to my point, which was originally that clear statement rules, ordinarily they operate in the following way. Congress can do the thing in question as long as it's clear. Here, Congress is clear by hypothesis, by the questioner's hypothesis. Can it do the thing in question? Well, I don't know. That's a non-delegation doctrine, isn't it? And so the question illustrates the problem of the substantive canon formulation or the clear statement formulation of the major questions doctrine.
Well, Elon, I think that's going to be the last word from you. So I just want to say thank you so much for joining us. Jonathan, I'll give you one last word too, answering this question. I just want to say before we go, folks, what I've learned is that if you ever want a narrow interpretation of a statute, bring a non-delegation challenge to the statute and describe it in extravagant terms. And so maybe the courts will construe it narrowly to avoid your lawsuit. But Jonathan, any closing thoughts on the interaction between these doctrines and what Congress does? This too is something you've written on your own and with Chris Walker. So any final thoughts on Congress and how that plays into these doctrinal developments?
Well, I mean, I agree with Elon that it's too soon to know whether or not Congress has gotten the message, but I certainly do think it imposes a burden on Congress or an obligation on Congress. And I think one way to look at where this is most significant is there's been a practice in a lot of areas of agencies trying to pour new wine out of old bottles, taking a statute that was enacted in, say, 1996, if we're talking about telecom, earlier than that, if we're talking about most of the major environmental statutes, and try and figure out how that statute can be twisted or warped or stretched to deal with some contemporary concern. And it's pretty clear to me that across these cases, we've seen the court saying that that's not the way you do it. Statutes are enacted to address particular sorts of problems in particular sorts of ways at particular times. And if at a later time there are new problems or new ways of doing things, Congress has to re-enter the picture in order to make that possible. And I think that puts an obligation on Congress. Whether Congress is going to meet that obligation or not, too soon to tell.
Okay, I changed my mind. I want to ask one last question from the audience. But guys, I'm putting you on a clock on this one. Let's keep it short and sweet because I know Sarah is waiting to wrap this up. But the question from the anonymous attendee about agencies or an administration basically refusing to spend, refusing to act. We tend to think of these debates around major questions doctrine and so on in terms of agencies being too ambitious and going beyond their statutory mandates. But right now, in a lot of the cases, and especially a year ago in the debates around DOGE, there were questions about the agency using or abusing discretion in the other direction, not getting too big, but going too small. The things we discussed today around deference and delegation, is there anything different about an agency going too big versus too small, or should the same tools be applied for an agency that seems to be aggressively narrowing its mandate or its sphere of activity rather than expanding it? Again, we're up against time, so let's just be quick. And thanks to everybody who asked questions, including Charles, Charlie, and Chad, who I didn't get to.
I'll try to be as controversial as possible, as little time as possible. I
Oh,
think
good.
it'd be a question of the suspending and dispensing power. The president has the power, the duty to take care that the laws be faithfully executed. That means you can't do what Charles II did, and which is James II, which is suspend the laws, say that I'm not going to enforce them, or to dispense them, give legal authorization. I would have thought that the Biden administration not detaining certain individuals at the border that were required to be detained by the statute was a suspension of the law. The Supreme Court said no, that is prosecutorial discretion. And if that's prosecutorial discretion, then why isn't impoundment prosecutorial discretion? Because if Congress can say, shall detain, and that doesn't mean shall detain, why does shall spend mean shall spend? As opposed to say, well, we have limited resources and we want to make sure it's spent appropriately, and so we got to put a pause on this. I think it's very tricky, and I will stop there with like at least 3 or 4 controversial propositions.
And Jonathan, before you get the last word, Elon's answer reminds me that one of the major questions, doctrine, from the Biden administration was about the administration refusing to do something, right? Refusing to collect on student loans. Is that at all analogous to what we're talking about here with the example from Anonymous was in terms of the CFPB shutting down a lot of its work? How do you think about this?
Well, I do think the question of whether an agency is exercising power it does not have is different from whether or not the agency is failing to follow the instructions that Congress gave it. I think they're both important. I think they both implicate the president's obligation to see that the law is faithfully executed. I do think the questions are different. The last thing I'll just throw out is the ability of courts to remedy that sort of violation is also different, right? It's easy to see how someone has standing to say the government is doing X to me, it doesn't have the power to do it. It often can be much more difficult to say the government should be doing this thing and it's not. And it's not always clear who can sue over that. So there are a bunch of reasons why that latter scenario often presents both a different and more complicated legal question.
Great. Well, thanks again to both of you. Thanks to everybody for joining us and letting us run this a little bit long. And with that, I'll turn this back over to Sarah to wrap up.
On behalf of the Federalist Society, thank you so much to Professor Adler and Professor Werman for speaking with us today, and to Mr. White for moderating. We're so grateful for your time and expertise on this important topic. Thank you to our audience for joining us. We really appreciate your participation. You can also stay up to date with other announcements and upcoming webinars on our website, fedsot.org. Thank you once more for tuning in, and we are adjourned.